On 8 July of this year, the Commission sent you a request for the submission of the 5-year declaration of assets and personal interests. On 13 July, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on the 1st of July of this year. The Commission sent you 4 rounds of questions on 15 August, 7 October, 2 November and 16 November, respectively. You were asked a total number of 21 questions, including 63 subparts, and 12 of those questions included a request for further documentation. According to Article 3, Paragraph 4 of the evaluation rules of the Commission, a candidate may not provide information, documents or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless, of course, the candidate provides sufficient justifications, therefore. Members of the Commission will now start with asking you questions. Mr. Vitaly Miron will start with asking questions first, followed by Nadezhda Rytjevsky. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Mr. Vitaly Miron, you have the floor.
Mulțumesc, domnul președinte, pentru această oportunitate.
Thank you, esteemed Chair, for this opportunity. I'd like to greet you again, Mr. Sorbalo. I will start with a factual description, and then I will ask you a couple of questions regarding this matter. I hope the questions are worded in a way and are of such a nature that they will allow you to be as brief as possible. So, in 2008, the President of the Superior Council of Magistracy has initiated a disciplinary action against you that resulted in a disciplinary board decision of 23 December 2008, whereby you were sanctioned with a warning for violating the obligation of impartiality and for a serious violation of judicial ethics. The decision was based on the fact that you issued a decision on the 15th of August 2008 that declared illegal the conduct of searches at the office and home of a lawyer that had represented you previously in a criminal case in 2007. The disciplinary board decision was could be appealed with the SCM within 10 days. On the 13th of January 2009, the author of this disciplinary procedure, that is, the President of the SCM, has challenged the decision of the disciplinary board, arguing that the disciplinary sanction seemed to have been too mild for the committed violations. On the 22nd of January 2009, the SCM allowed for their respective appeal and amended the decision of the disciplinary board of 23 December 2008, proposing the President of the Republic of Moldova to dismiss the candidate from the position of dismiss you from the position of investigating judge. The SCM found that the actions of the judge were incompatible with the position of a judge, because it caused serious damage to the prestige of justice. On the 31st of July 2009, by decree of the President of Moldova, you were relieved of your duties as investigating judge. You then challenged the SCM decision before the Chisinau Court of Appeal, and that application was rejected, and then the SCJ also rejected your second appeal, having supported the Court of Appeal decision. In 2019, the European Court for Human Rights informed the Moldovan government that it was examining a complaint that you submitted, and the parties hadn't reached an amicable settlement, but the governmental agent on the 24th of December 2019 has submitted a request of review to the SCJ, requesting the annulment of the 7th of July decision 2009, and expressly thus acknowledging the violation of your right guaranteed by Article 6, paragraph first paragraph of the European Convention. On the 5th of February 2020, the Superior Court of Justice annulled the SCJ decision of 7th of July 2009 and expressly acknowledged the candidate's violation of the candidate's right guaranteed by Article 6, paragraph 1 of the European Convention. On the 1st of July 2020, the Superior Court of Justice accepted the candidate's request, annulled the Chisinau Court of Appeal decision of 21st of April 2009, and issued a new decision by which the SCM decision number 14/1 of January 2009 proposed the candidate's dismissal was annulled. Following the SCJ decision, the SCM reinstated the candidate on the 7th of July 2020. The candidate was paid a gross compensation of 1.8 million Moldovan lei salary for the period that you did not work as a judge, and to date, however, you have not been fully reinstated as a judge, you did not have the right to examine cases, and you did not pass yet an extraordinary evaluation in order to be fully reinstated. On the 2nd of October 2020, you requested the SCM to undergo the evaluation, but there was no response or answer from the SCM. And now the questions. Mr. Sorbalo, in the decision of 23 December 2008, the disciplinary board has concluded that you violated the obligation of impartiality and the serious violation of judicial ethics and applied you a warning, right? Yes, that is correct. Indeed, that sanction was imposed as a warning. But now, if I may, esteemed Commission, I would like to provide a couple of specifications of explanations, now perhaps even anticipating some of the further discussions. After all the judicial proceedings, and after the decision of the Supreme Court of Justice was pronounced, and after the decision of the Superior Council of Magistracy, and after I was reinstated in the position, I have filed with the Superior Council of Magistracy an application. Unfortunately, I was not prepared, but if the Commission believes it necessary, I am ready to make that application available to you as well as the answer to that. It has to do with the fact that in 2010, if I'm not mistaken, if my memory doesn't fail me, the Prosecutor General withdrew his notification that was submitted to the Superior Council of Magistracy. I would like to repeat that. The Prosecutor General withdrew the notification. Now, as for the disciplinary procedure, that was initiated precisely on the basis of that notification from the Prosecutor General. And now, considering that another notification to the Superior Council of Magistracy was not submitted, there was no other document that would have served as a basis for the sanctioning of Judge Sorbalo. I asked the Superior Council of Magistracy to re-examine the disciplinary procedure and to terminate it, to put an end to it. I have later received an answer from the Superior Council of Magistracy, an answer in which said that, considering that the duties of the Superior Council of Magistracy at that time were limited, that matter was to be examined by the next council at one of the plenary meetings of the council, that is, of the board, that is, of the disciplinary board for the disciplinary procedure. Now, Honored Commission, if I may, I would like to try to dot all the I's and cross the T's regarding this matter. Because for 14 years now, it has been coming back, and for 14 years now, I have to go back to it. Although these events happened 14 years ago, nobody over this time span of 14 years has ever told the truth. Allow me to interrupt you, Mr. Sorbalo. We actually have a number of questions regarding this matter, so I believe they will support more clarity. So let's have a step-by-step approach and follow the consecutive questions. So let's start with the beginning. So on the 23rd of December 2008, the disciplinary board has imposed a sanction on you in the form of a warning that established that the obligation of a magistrate to be impartial was violated, and there was a serious violation of judicial ethics that was imputed against the person concerned in disciplinary sections. Is that correct? That is correct. So, in that decision, what were the grounds for the decision? That decision, as well as those who adopted it, they based that decision on the fact that, they continued with the idea that was launched by the prosecutor's office. They had this notification for me to be sanctioned, but they reached the conclusion that the judge, Stanislav Sorbalo, has examined a complaint of his lawyer, and the judge was supposed to recuse himself from reviewing the complaint filed. Honored Commission, I would like to declare with the utmost degree of responsibility in front of you and in front of the entire society, I did not examine any document signed by the lawyer that represented my interests in a traffic accident where I was the injured party. Not one document, not one complaint was signed by me. To make it clear, I would like to tell you how things actually happened. Excuse me, but this is a matter that we will further discuss, and we have a question about it. So I'd like to invite you to first answer briefly the questions so that we can continue with the hearing. But I reassure you that all the information that you would like to tell, you have the possibility to tell them later. I believe they're very important. They are very important, and we're not going to overlook them. We have separate questions to address that. Let's have this step-by-step approach. There were two decisions whereby you were given a warning, and then there was a proposal for you to be relieved of your duties. Now, speaking about the first decision of 23 December, you did not challenge the decision of the disciplinary board. Is that correct? Correct. Why didn't you? I believed that, well, having seen the attitude of certain people, I thought that it was not worth it. There was no point in doing it. I have to be honest with you. Now, to clarify, you disagree with the grounds in that decision whereby the sanction of warning was imposed on you, but you did not challenge it for what reasoning? For what reasons? I believed that, well, seeing the attitude of certain people, I drew the conclusion that there was no point in me challenging it. Now, very briefly, please, do you agree that there has been an ethical violation as stated in that decision, and that violation is imputed to you? I disagree, and I tried to provide more detail of the events as they took place. If you allow me, I would like to try to provide you the details, all the details of the events back then. Fine. As I said, every element and every ground that is in the decision will be looked into separately, because there are certain aspects on the basis, well, that were imputed to you. We will address every separate aspect, but let's first of all clarify the warning situation. So there was first a warning, then it was challenged, and the sanction was changed. The decision of the disciplinary board was amended by a decision of the SCM of the 22nd of the SCM of the 22nd of January. So only the sanction changed, not the grounds alleged, right? Yes. Now, for general understanding, at present, are you or are you not fully reinstated in your position of judge? I'm not. Please confirm, because we've had a communication during the Q&A rounds, but I want to be certain that what I understood was right. Please confirm that on the 2nd of October 2020, you asked the SCM to carry out an extraordinary evaluation of you for you to be reinstated in your position of judge. I did so. Actually, I filed two applications, one related to the evaluation and the other one related to the appointment. The evaluation application, yes, indeed, there were two applications. One, there was the first application, and a couple of days later, another one. What was the response, the answer of the SCM?
Besides the correspondence that you submitted to the Commission that reveals an interaction between you and the SCM, did you undertake any other steps to be reinstated? Yes, I did. Given the recent legal amendments in the Constitution, I filed a request to the SCM on my appointment before the age ceiling, and given the decision of the Constitutional Court of the Republic of Moldova, where also, well, from the content of which it means that before the age limit all judges should be appointed, I filed a request in this regard, and I haven't received any answer. Now, Mr. Sorbalo, we will discuss in detail the topic that you wanted to. Chairman, if you allow our colleague to ask those questions. Thank you very much. Mr. Sorbalo, you provided the decision of 15 August 2008 to the Commission. We received it. And according to that decision, you, as an investigating judge at Bălți Court, declared illegal some searches conducted on 3rd of April 2008 in the office and home of the attorney who represented you in a case about a traffic incident. The searches took place on the 3rd of April, both at the office of that lawyer and at the place where the former wife of that lawyer lived. Two legal entities that were located on the same address as that lawyer's office that was searched filed complaints about the search on 23rd of May 28, and the former wife of the lawyer filed a complaint about the search on the 26th of May. If something is wrong in the facts that I mentioned, please correct them now. I want to specify just one thing. I did not examine a complaint against the searches at the home or office of a lawyer. That's the issue. I examined complaints against the search that took place at a company. We don't give names, indeed. It was a limited company. It was an association who had the office in the same building and who were searched also based on that ordinance issued, by the way, by a person who is not empowered by law to issue search orders. I expressed my opinion in that decision very clearly. So based on the same search warrant to search the workplace of that lawyer, everyone who was found in that building was also searched. The limited company, the NGO, all their bookkeeping documentation of the limited company was taken, and thus it blocked their work. And I believe, well, I understood. So, for the same decision, you made reference to the search that took place at the home of the lawyer's house, but it was actually his former wife living there. I would like to add, it wasn't lawyer's home, it was his former family's home, because when I examined that complaint, documents were provided that there was a divorce between the spouses, and the lawyer had another family with another woman living at another address, and that woman was living with another man. Like, they already had different families, which means another apartment. Not the lawyer's house was searched. Please clarify. According to the legal provisions in force at the time, in 2008, Article 313 of the Criminal Procedure Code said that the time for submitting complaints to contest the legality of searches as 10 days. Is it right? Yes. Based on what legal reason you accepted to look into these complaints that were filed almost 2 months later from those searches taking place? If I remember correctly, These complaints were first sent to Chișinău Court. Then the Supreme Court of Justice declined their competence, and they were submitted to Bălți. Then they were redistributed to me for examination. At that time, I did not find it as complaints being filed with procedural violations. But according to the information we have, they were filed on 26th and 23rd of May 2008. The search took place on April the 3rd. So the complaints were filed 2 months after the search. I am not ready to answer that now. Well, this is in your decision. This information is in your decision. So it says which were the dates. It's page 2, and talking about family members of the lawyers specifically, you can see the date on page 2. No. Okay, let's continue, and we'll see in the end if more time is needed. I just don't remember these details. You know, this matter, well, I remember that once this case was distributed to me, I talked to the management of the court with the first question that I raised was, given that I was a beginner judge, you know, we have all been beginners at some point in our activities. So I raised the question about the bias, or potential bias that I could have. So when you received this complaint, these 2 complaints that were assigned to you, from the text of the complaints, it was clear to you that this is about a search that took place in connection to a lawyer that represented you in a different case. Well, the case files were not submitted. I just saw the surname of that lawyer. So not even getting into the essence of the case, I immediately talked to the management of the court to see how we solve this in order not to be blamed later on of actually what I got to be blamed for, of being biased. Together with my more experienced colleagues, we studied, and at higher courts as well. We got to the conclusion that since in front of me there is no file regarding that specific lawyer, there is no document or complaint signed by that lawyer, but these are third parties who have nothing in common with the work of that lawyer. For this reason, we got to the conclusion that there are no circumstances that would oblige me to refrain from examining these complaints. Should it have been a complaint or a document submitted by the lawyer himself, I would have certainly recused from examining these complaints. Well, you now confirmed, a bit anticipating, so you had doubts. When you received those complaints, you had doubts that there may be a conflict of interest, is it right? I mean, since you just said that a couple of minutes ago. Yes, I want, because you asked the management of the court, and who else? I consulted colleagues with more experience, because it was the beginning of my career, and I didn't have such cases before. What was the procedure in 2008 if a judge has doubts about the perception that could be generated to the court proceedings about the attitude? What was the procedure? The procedure was the same as today. If there are circumstances that would oblige me to refrain, such a conclusion is issued, I refrain, and that's all. So first, you should apply for abstaining from, and this should be submitted to a different judge, or how was the procedure itself? Well, if it is found, let's say I received the complaints and I found circumstances that oblige me by law to refrain from examining these complaints, I would have issued a conclusion refraining from examining them. In this case, I did not reach the conclusion that such circumstances were present. Was it yourself that reached that conclusion, or were you convinced by your colleagues? It was my personal conclusion after I studied thoroughly the Criminal Procedure Code, the comments to the Criminal Procedure Code, and consulting colleagues with more experience from whom I learned. I think everyone learns good things from more experienced colleagues. Understood that. In your answers, and please correct us if we didn't understand something correctly, when these complaints against the searches were received, Bălți Court, there was a request from the Supreme Court of Justice for this case to be examined by complaints. Why did Bălți Court issue such a request? Well, if I remember that correctly, there were some requests of a prosecutor from the Chișinău Anti-Corruption Prosecutor's Office. And given that request was submitted not by me, by another colleague of mine. And given that the request and the people who issued those documents are located in Chișinău municipality, for that reason, there was requested for the examination to be moved to Chișinău. Subsequently, the Supreme Court declined their competence on this case and said that it was Bălți Court that was competent to examine it, because it was taking place. And in the conclusion of the Supreme Court of Justice, the competence was established for Bălți Court, not to an individual judge from Bălți Court. Yes, it was for Bălți Court, and given Article 313, that the complaints were for an investigating judge, and in Bălți Court at that time, I was the only investigating judge in Bălți Court appointed by presidential decree. And what you said before, that you asked the management of the court and your colleagues with more experience, these requests, did they take place after the conclusion of the Supreme Court was issued or before? Do you remember? I can't say. I don't want to mislead you, so I can't say I don't remember. It's 14 years ago. Please explain if now you believe that you examining these complaints is or was a conflict of interest or not, and please provide the details that you wanted to mention before. Before answering your question, I would try to describe in details how actually things happen, and I will try to shape a case, similar case, in order not to, by mistake, not to mention the name of the company or people involved in that case. So let's say we are all in Chișinău municipality, number 1 on Serghei Lazar Street. In this building, the commission is working. I work, let's say, I also work here. Colleagues from the media work in this building. In the neighboring room, probably some of the teachers or trainers educate the next generation of prosecutors and judges. And at a certain point in this building, a team comes in prepared to carry out a search at the address 1 Serghei Lazar Street. At the entrance to the building, the officers show the ordinance. Let's say it was about Sorbalo. It was a criminal case against, let's say it's against me, not to offend anyone here. So at the entrance to the building on 1 Serghei Lazar Street, the officers show the ordinance, the warrant to search the workplace of Stanislav Sorbalo on 1 Serghei Lazar Street. In parallel, besides me, the officers search each and every one who is here. You, the teachers in the next room, esteemed media representatives. Pardon me, Judge, please make reference to the case. I want to explain to make it clear for everyone. Because you maybe know some things, but maybe someone doesn't know, so I just want to explain these things in detail. But please make reference to your case and that conclusion. So when I looked into the complaints of third parties who have nothing, again, nothing in common with the work of that lawyer, that limited company, that NGO, I only found that they were searched illegally. I believed and I still believe that in Moldova you can't search everyone in a wholesale manner, all people, all entities. Certain legal conditions have to be fulfilled for one or another person to be searched. And again, they searched all persons based on one and only search warrant. There was no search warrant for the limited company, for the NGO, for the other people. It was only one, the workplace of a lawyer. And based on that very same warrant, everyone there was searched. They took the records, documentation from everyone who was there. Esteemed Commission, with your permission, Chairperson, I would like to shed some light to make it clear for everyone what is being hidden behind this criminal case, who actually had some interests or hidden purposes. Because I believe that the citizens of this country and Masu should know the name of our heroes. Chairperson, I request your permission to make a phone call, and for us all, we will all listen to some things that will help us all shed light on everything. This is strictly connected to this topic. Mr. Sorbalo, during the evaluation, the object of evaluation is the financial and ethical integrity of you. And as you can see, The questions we ask are strictly about this. The purpose of our evaluation assessment is not what happened there, what was in that case. That is out of the competence of the Commission. If you demand that, there are some methods, including press conferences, where you can make statements about that conclusion, that decision. Now we were just trying to clarify some aspects about the existence or lack of reasons in the way it was declared. Should you have refrained from this or not? So from these points of view. So, Chairperson, please, you can, of course, explain. But I finished my questions about this topic, but my colleague has some other clarification questions. Mr. Sorbalo, about your last statement, I was asking myself now, why didn't you do that previously, at the previous stage? Because what we discussed now at the hearing was actually approached in the Q&A rounds, and you had the possibility, maybe even the obligation, to provide all relevant information before the hearing. We need to appreciate things correctly. I wanted to make a phone call to one of the people who was searched, then for them to tell you what was taken by esteemed gentlemen who were. They took $2,000 that were not returned today to those people. That's why they were so angry against Sorbalo judge who ruined their plans somehow. Because if I was to overlook how these gentlemen were doing their work, they probably wouldn't even read the decision that the judge was going to issue. They were only careful about the last sentence, that everything was legal from their point of view. But once I declared the search is illegal, I ruined their plans. Because if they continue to work like that, the list of goods that were taken, and not until even today, they were returned to citizens. I, as a judge, cannot pretend not to see such unlawful acts. I swore to protect rights and freedoms of people, and I will keep doing that. Mr. Sorbalo, allow me to ask you some additional questions to give some clarity, at least for me to understand. This is how I was brought up. I am looking at this from a procedural point of view, and if I'm wrong, please correct me. On April the 3rd, 2008, a search took place. We don't look to the merits. It's a thing that happened, a search. On May 26, 2008, in violation of the timeline of a criminal procedure, well, with a delay, these complaints were filed. The complaint that the court was supposed to talk about admissibility of that. It was not about the merits of the case. It was only about the procedural timeline, if that was procedural terms. So that's my first question. What was the de jure de facto reason that allowed Bălți Court to examine these complaints in violation, well, these complaints that were filed in violation of the procedural rules, not looking into the merits? Well, from the archive of a court, I should have taken. I don't remember the details, but from what I remember, something was there. I mean, it was either complaints were redirected somewhere. Probably this says this is the date when they were returned from the Supreme Court to us. So it says clearly, Judge, in your conclusion, that they were filed on that date. I somehow accept your answer or explanation that is missing. Well, previously you said the home of a lawyer. The idea was clear. You expressed the reason and in the communication with us that he had another family. But I want to understand. On April the 3rd, 2008, when the searches took place, the domicile of that person was where? It was on a different address where he was living with another person, not de facto or de jure? De facto. He was actually living somewhere else. So the search, that address in the Slobozia sector of Bălți municipality, but he was living in the 8th district of totally different part of it's not like it was in the next door or something. Different place within the town. And the last thing here, you still declared during the hearing that there was some perception that there may have been some, maybe not conflict of interest, but some situation that would doubt you. Well, but you could have been seen as biased because you asked your colleagues some advice. But the law provides clearly that when you have such a feeling, you file an abstention request that another judge should have examined. You did not do that. Why? I did not reach the conclusion that in that case, there were circumstances that would oblige me to refrain from examining these complaints. You know, if the complaint in front of me were filed and signed by the lawyer, or if in front of me there were some materials, and as a result of looking into them, I would have expressed my opinion about that person being guilty or not, or if my decision would have influenced the conduct of a criminal investigation about that person, I would have certainly abstained from examining this. In this situation, I did not reach the conclusion that there are circumstances to oblige me to abstain from examining it. Again, I repeat, these complaints were filed by third parties that have nothing in common with the work of the given lawyer. Thank you for your answers in this respect. Pardon me, my colleague has another question. But the searches that took place on the three entities, well, two entities and former family, they all took place in relation to a criminal case envisaging that lawyer. Is that right? Yes, and based one on the same warrant. Yes, but they were part of a criminal proceeding against that judge. They were not part of a criminal proceedings. They were searched for the following reasons. The first one, the search at the office address, for the simple reason that they were also located at the same address, and the people living at the address where was the domicile of the lawyer, they were searched for the reason that they used to live together, but he was not living there for many years then. And documentation was provided confirming that there was a separation act between those spouses, and they already had different families living on different addresses. Pardon. Another aspect that I would like to approach. Mr. Sorbalo, in 2020, your son purchased an apartment of 42.6 square meters in Chișinău, worth of 253,985 lei. That's estimated 12,866 euros. According to the sale purchase contract of 20th of November 2020, according to the information from real estate agencies, the market value of similar apartments at that time was around 30,000 euros, which would be 592,000 lei. The son bought the apartment based on funds donated by you that you declared in your annual declaration in 2020 in the amount of 700,000 lei as a donation. When asked about the price difference in the contract and the market value, you said that you could not offer any additional explanation about the price of the apartment because that was negotiated between your son and the seller, and that you had the task to monitor that your son had, that you had the obligation to monitor that your son behaves appropriately. That the candidate, you also said that any contract concluded between the parties is negotiated under favorable conditions for the contractors, in free form and under conditions of confidentiality.
In 2019, your son purchased a Ford Focus from 2016, that is a manufacturing year, for the price of 20,000 lei, according to the contract presented to the Commission, and the market value of a similar car actually varies between 8,000 and 8,000 euros, and that's about 172,000 lei. When asked about the source of funds for the son to purchase the car, you explained that you donated your son the amount of 160,000 lei to purchase the car, and the amount of 160,000 included the selling of your car for 40,000 and a loan of 120,000 lei contracted by your family. You also mentioned that you personally helped your son to drive the car home because he didn't have his identity, his driver's license with him. When asked about the difference between the contract and market price of the car, you said that you didn't know under what conditions the son negotiated and purchased the car, and if there was a difference between the market price and the one stipulated in the contract, that in general you didn't know how much the car cost. Was the information so far correct? Yes. I would like to ask you a number of questions. In 2019 and 2020, you donated your son an amount of 860,000 lei. Is that correct? Correct. In 2019, your son purchased the Ford Focus, manufacturing year 2016, and you mentioned that it was purchased out of donations amounting to 160,000 lei. Is that correct? I did not say that that car was purchased out of the donation of 160,000. I mentioned that I donated my son the amount of 160,000 lei. Now, what he paid for the car and how he negotiated that and how much he paid for that, for the car, I don't know. Well, we have the price from the contract. Well, if that, I know what the amount is in the contract, as I provided it. But in the second round of questions and answers, you mentioned donating 160,000 for that procurement. I donated my son 160,000 lei. I did not hide this amount, and I declared it in the declarations. Both I and my wife declared it, because she's also a declarer who is supposed to submit the annual declaration of assets and interests. And I also indicated the source of the 160,000. I provided all the details required without hiding anything away. Yet you said you didn't know what the car cost and what was negotiated, yet you helped your son to drive the car home. I didn't help him drive the car home. I, at the time, said the following thing, that under my name, I mean, what I did, I helped him drive the car home from Soroka. And on my name, a power of attorney was drafted by the seller, because my son did not have, at that moment in time, any ID documentation. So that's what I said, and I reiterate it now. So it's on my name that the power of attorney was written, a general power of attorney that the seller drafted and signed on, because the seller was supposed to travel abroad as a matter of emergency, and there was no time for all the paperwork to register the car on the name of my son, and for that reason a power of attorney was drafted and my name was written on it, and that is perhaps one of the reason for the price, because the seller was supposed to go abroad, to travel abroad as a matter of emergency. Now, on the basis of a question, it triggered a memory that it was a Saturday, if I'm not mistaken, it was a Saturday. Sorry, but that is not something that I asked you about. It's just I remember that he was in a hurry, he was in a haste to leave Moldova, so that's why we decided to develop this power of attorney. Mr. Sorbalo, the question is, did you see the car? I did. Did you drive it? Yes. Which means that you saw what condition the car was in. Theoretically, yes. So out of the information that we have, you previously had other cars that you sold. So you sold a number of cars in your lifetime. Yes, and I can name them all. A Vaz 108, 08, 09. I mean that it was not the first transaction of this kind. So you know what a car is and what the price of a car is. I don't know what the conditions were, what was negotiated, what were the terms negotiated by my son. I don't know. I can only assume that on the basis of the fact that the seller had to leave Moldova as a matter of emergency. He needed the money as soon as possible. So we established that 160,000 was donated to your son by you, and 40,000 was out of the sale of a Renault Megane Scenic. That is correct. Now, you personally, do you think it's plausible that a Ford Focus of 2016 bought by your son in 2019 could have costed 20,000 lei? Does it sound plausible to you? I want to be understood the right way. I cannot appreciate it in any way. If you ask me how much a car costs now, I don't deal with cars. I don't know what is the cost of or the price of such a car even now at present. I accept your answer, yet I want to be convinced that I understand your position. So do you believe that this car in 2019 could have costed 20,000 lei? I don't know. Maybe. I don't know what could have been there, what could have happened there, what terms were negotiated. I don't know what could have. But you previously tried to explain why such a price could have been negotiated. You said that perhaps the seller was in a haste and had to leave. Do you have any perception, any idea as to why the seller of the car sold that car to your son at a price that is that small compared to market value? I don't know. One thing that I can say for certain out loud is that not me, not my family has had the intention to hide any funds. From the very outset, I and my wife, we declared openly that we donated our son that amount. We had no intention of hiding anything whatsoever. Now, as for the terms negotiated, how that was negotiated, I cannot answer that. In 2020, now moving on to a discussion about the apartment. In 2020, your son purchased an apartment of 253,985 lei. That's about almost 13,000 euros, according to the sale purchase agreement of 20 November 2020. Now, the market value of a similar apartment at the time was 30,000 euros. That is about almost 600,000 lei. Please explain how much did your son pay for that apartment? Well, approximately, I'm going to answer approximately the same. I declared openly and honestly with myself and my wife, we declared the donation to our son of 700,000 lei. And I declared where that money was taken from. I donated it to my son, but I'm going to provide a little bit more detail around it. My son is a medical student. He wanted to go abroad. As a parent, I believed it was better for the future doctors to remain here in this country. So I and my wife decided to donate him money so that he could remain here, buy a place to live here, remain in the country. And we declared the 700,000 amount that was donated. I declared it in the annual declaration, and so did my wife. I want you to get me right. Now, how my son managed this money and how much he paid for the apartment, how much he paid for renovations, and what he paid for furniture and all the other things. Now, apologies, but I do not know these details. I said it in front of the Commission, and I would like to reiterate it that as a parent, I kept monitoring that my son had financial sources that are only acquired legally. I monitor that he behaved adequately and that he didn't come in conflict with the law. This is something that I've always kept an eye on. Now, with regards to how he is managing his funds, to how my son is managing his funds, it's, well, no, me, not my wife are looking into that. Our son is already an adult. He has the capacity to act, so he's on his own. Mr. Sorbalo, a couple of seconds ago you said that your purpose is to monitor that your son has an adequate behavior and doesn't come in conflict with law. That is correct. Which means that at the time that when you sign a contract, you should make sure there is an actual price in the contract to not be in conflict in the law. Now, considering this active obligation that you've assumed, I'd like to ask you again. In 2020, he purchased an apartment. The contractual value is 254,000 lei. So that is the contract amount. According to the information that is available to the Commission, apartments like that, similar apartments, cost 30,000 euros. That is almost 600,000 lei. And since you said that you keep an eye, that you monitor, that your son follows the law and has a proper behavior, I'd like to ask you, at the end of the day, what was the price for that apartment? Is it the one from the contract, or is there another one? I am not ready to answer this question. I am not privy to all the details that were negotiated in relation to this contract. I do not know what are the benefits or the advantages that I would have won or that my family would have won out of it if the seller or when they negotiated that contract. I was not even in Chisinau at the time that the contract terms were being negotiated. So I wouldn't want to mislead you, and I also want to make sure that I am as honest as I can be, because I don't know. But I can certainly tell you that my son had funds that were legally acquired. I can say that with certainty out loud. I asked you in relation to the car and the apartment about what the real price would be, or whether you think it was established the right way, but in both cases you can't say anything about it. It's just I don't deal in cars, I don't deal in apartments, I'm not a real estate agent, and I'm just not aware of it. But looking at it as for instance, such a car couldn't have cost 20,000 lei. Do you have any ethical concerns around this fact? Because these assets, they were purchased out of the donations that you made included. And the prices that are indicated are significantly smaller than the market prices. I will talk to my son. I will ask him again about the negotiations and how that was negotiated. I just want to stand fair in front of you, and to be honest, I don't know the details of the negotiations. I understand you, Mr. Sorbalo. I don't have other questions, but considering the complexity of the previous questions, if there's anything that you'd like to add, if there's anything additional that you'd like to share with the Commission, you have the opportunity to. Thank you, honored Commission. I would like to thank you for this opportunity to appear in this hearing in front of you and in front of the entire society. I did not prepare a particular speech. I was honest. I spoke from my heart with an open heart in front of the Commission. I have no intention of hiding anything. I have no intention of hiding anything from the Commission, from the society. I hope and I also trust the objectivity of the Commission, and I would like to wish the Commission the best of luck and I would like to wish the best of luck to all my other colleagues who will participate in this endeavor, in this pre-vetting evaluation. As regards the questions that were asked and were discussed today in the hearing, I would only like to provide some little clarification that in its value, I believe it carries an important value, in my opinion. Starting with 2008, when this whole story began about the ruling that I pronounced when I declared illegal the searches of certain people, well, in fact, nobody, those who actually set this off, well, none of those people who started this wanted to actually say that Mr. Sorbalo did not examine the complaint of the lawyer, but examined the complaint of other people. Nobody said that on the basis of one search warrant only, several people were actually subject to searches on the basis of one search warrant only, which is not acceptable in a state where the rule of law stands. When it comes to such criminal prosecution actions like searches, they cannot be carried out en gros, like wholesale, like all together, as in one single warrant and let's search everybody living in a neighborhood. That is not acceptable. What I did in 2008 was that I set forth my position that I arrived at, which is that the searches were carried out in violation of the criminal procedure law, and I declared those searches illegal. Having pronounced that ruling, I did not pursue any goals, any particular goals or interests. The only purpose I was guided by, the only interest that Judge Sorbalo had when issuing that ruling was to observe and to make sure that the law is enforced, to observe the law and to make sure that it is enforced. Thank you for your attention, and if there's going to be anything else to answer, I'm ready to answer any of your questions. Thank you.
Our colleagues who would like to have additional questions. I have one last question going back to the last issue that we discussed with you, where you confirmed that you gave a donation to your son of 860,000 lei for two purposes, for the purchase of a car and for the purchase of an apartment. But if I just make a quick calculation and we were to follow the official prices that were mentioned, 20,000 for the car and 250, let's say 255,000 lei for the apartment, that comes to a 275,000 lei. But if that were to be the price, why would you then donate 860,000 lei to your son if the total prices of those two objects are roughly 275,000? That's still a calculation thing that doesn't work with me.
When I and my wife made that donation back in 2019, the money for the car, we took as a starting point so how did we donate the 160,000? I mean, where did it even come from? So I declared to the Commission that we had a car, Renault Scenic, that we sold for 40,000 lei. And I went to one of the banking institutions, to one of the banks, and I was thinking about taking a loan. And I asked, what is the amount that I could be given by the bank, considering that in 2019 I was unemployed. I did not have a job or workplace. You know about the situation. So in my family, Only my wife was the one that had a job that was employed. And considering that situation, when a loan is to be given by a bank, the first matter that they are considering is the income of the family. And when calculations were made by the banking institution as to figure out what amount they could give us as a loan, they said that they could give us, what they said was, considering the income of your family, we can give you 120,000. So that's how we then reached the 160,000. So the money that we took from the bank and the 40,000 out of the sale of the car. So that's how we got to the 160,000. What the actual price of cars is, as I said, I'm really not knowledgeable about such matters because I don't deal in these. I mean, maybe you noticed out of the information that was provided that I'm not one of those people who buy and sell half a year later. So for a number of years, for many years I had a Lada and I kept driving it. I drove and drove it until it started to fall to pieces. So I have to admit, it's just not something that I'm not knowledgeable about. So I gave him that amount. Now, how much he spent and for what? I don't want to be misunderstood. I want to be honest. I don't know about all the details. All I said is that I assume, I believe that, and also considering the question asked by Mr. Vitaly, I remembered that when a conclusion was reached that a power of attorney needed to be drafted because that person didn't have the time to come back again to do all the paperwork of transferring into the ownership of my son and so on and so forth, because that person had to leave as a matter of emergency. Maybe that was the reason. I don't know for certain, so apologies, I don't want to.
If it's about the same issue, okay, because I have regarding the first one.
Okay, then Victoria, you first. Yeah.
Quickly, you sold the Renault around the same time your son bought the Ford Focus, correct?
Renault was sold before that, because when the son bought the Ford Focus, at the time he already had the money. So we sold the Renault much ahead of that.
Okay. So didn't you think it odd that you sold the Renault, which was more than 10 years older than the car your son bought, for half, I mean, for twice what your son paid for the Ford Focus?
I did not pay attention to that matter. I had no possibility to know that I would have to, at some point, explain the conditions in which my son made the procurement. If I had known that this would come up, maybe I would have paid more attention to this particular matter. And I would have then known what to say. But now, I can't tell you what were the terms under which my son bought that car. Just a clarification with regards to the ruling that you issued, because you mentioned, you reiterated that nobody tried, if I paraphrase it right, nobody tried to look into the essence of that, as in you having actually looked into complaints that had nothing to do with the activity of the lawyer that represented you. Yes. However, in the ruling that you presented to the court, you are actually saying that those searches were illegal and that it also affected the activity of the lawyer. So in that entire ruling, the name of the lawyer is referred to So there is the name of the lawyer. So how is it possible? Can you explain it again? What did you mean when you said that you believed that those searches had nothing to do with the lawyer that represented you a year before that? If I may, I will read from the ruling that I pronounced. So there's the initial part of the ruling containing 6 points. But can you please have a look at page 6, the end of it, and the beginning, so that the searches are to be declared as illegal because it violated the rights, and then there are the two entities named, and the rights of the citizen, the name of the lawyer, as regards his professional activity as a lawyer. So in the initial part of the resolution, in the disposition, I stated the following, that the complaints filed by the civil association and the name are partially admitted, and by the limited liability company, the name of that, and by the citizens, and the names and surnames. And it says acknowledged as illegal the searches on this and that street in Bălți municipality on the basis of a warrant of criminal prosecution officer and the name, which renders illegal all the actions carried out as part of the searches or in the framework of the searches on this particular street in Bălți municipality. So it acknowledges as illegal the searches on this and that street in Bălți municipality on the basis of the order of the criminal prosecution officer and the name of that person, which entails the illegality of all actions carried out in the framework of the searches on this and that street in Bălți municipality. All the rest in the complaint are rejected. So there's obligation of the prosecutor to remove to remove the alleged violations, and I did not comment on whether there is guilt or not, or I did not comment on any materials that would have and could have been signed off. I just looked in the complaint of third parties. You read from these excerpts from your ruling, so you acknowledge the illegality of all the actions of searches on those addresses, including the searches that were carried out at the lawyer's headquarters, because you said all, wasn't the word all actions? You just read it. That is, well, it included the lawyer's premises, but you just read it. I meant the complaints that were filed by the respective people. You cannot examine a complaint, but pronounce a decision or ruling with regards to another. But you said all searches on this and that address, that is, including the situation of the lawyer referred to. As regards the searches at the lawyers, I couldn't have come up with an opinion because there was already a court decision on that matter from a judge from Chișinău. So I did not comment, I did not address the searches regarding the lawyer. I addressed the searches regarding the limited liability company and the NGO. I couldn't have addressed the searches at the lawyers because there was the simple reason of a court decision already in place.
Any of my colleagues? If that is not the case, then normally I would give you the opportunity to make a brief closing comment, but I think you already did. Of course, if you would like to have another comment, then please go ahead.
No. Mulțumesc.
No, thank you.
To the end of the hearing this afternoon. I thank you for answering all the questions by the Commission. As you know, the Commission now will withdraw for deliberations, and as much as possible, the Commission will come with a decision within a month after the date of this hearing, and I hereby declare this hearing closed. Thank you very much again.
Goodbye.